welcoming remarks and welcome you all today. This forum collects everyone who is interested in peaceful dispute resolution in Ukraine and worldwide. For Pravo-Justice is one of the major partners of this forum, and sustainable development of mediation is important because it also furthers mature society, society that can understand each other and knows how to make a deal. And I think this is an annual important event which considers major achievements in the realm of mediation, as well as a great opportunity to search for some answers to some challenges. Of course, Ukraine continues for the third year in a row and live under very difficult conditions. We are in the middle of the war, but Ukraine is at the same time moving towards EU membership. And here I'd like to point out that mediation is not just a tool which complements the justice system and makes it more accessible and humane, but mediation should also be considered as a resilience method. And this is a way where we can help people find understanding even under these complex circumstances that Ukraine finds itself. Ukraine's experience is unique because Ukraine is going through difficulties, but it's not dissimilar to experience of other nations, such as Balkan, for example, region, where they, after the war, also used it to reintegrate communities. Now, in Europe, mediation is considered as part of restoring justice, and this is a good, reliable tool for society, especially during difficult times. Having said that, the state creates conducive conditions for this, and systemic vision, sustainable policy, and interinstitutional coordination is something that can make mediation better and make it work more effectively. Mediation is not an alternative to justice, but it is an inseparable part of justice. And indeed, this is the key to introducing culture of peaceful dispute settlement in any society. I believe Ukraine still needs to make a little bit more effort in order to improve coordination for sustainable mediation in Ukraine. But as Manfred has mentioned, the government of Ukraine is making efforts in order to get closer to Euro integration, and this is one of our commitments. And I hope that the forum, today is the second day, will be a good opportunity to look both at Ukrainian experience as well as other nations and switch to a vision where mediation can be used and where we can improve our vision of how it can be implemented. I'd like to thank the Ukrainian Academy of Mediation for promoting peaceful dispute settlement in Ukraine. I also thank all the partners. Your leadership and your drive inspires everyone, and furthers the culture of peaceful settlement in Ukraine. And I also thank the audience who found time to be with us today. I can assure you that Pravo-Justice will continue to support implementation of the roadmap and all the other processes currently underway in Ukraine in the context of mediation. Thank you. And now, on behalf of the Ukrainian Academy of Mediation, I'd like to welcome everyone. Throughout its existence, the forum became an important platform, and it's a great opportunity to summarize what happened during the past year and consider further ways of developing mediation. We develop new ideas jointly with practitioners, researchers, mediators, students, everyone who joins us. The forum was launched in 2015, and throughout these years, there were only 2 years when we were unable to hold the forum. The first time this happened on the first year of pandemic, COVID pandemic. And the second time we had to miss it was the beginning of the Russian invasion into Ukraine. The attendance is growing. This time it's 3,200 participants have registered. It's a great opportunity for people. The agenda is very diverse. We will be discussing a very wide range of subject matter, and we will try to help mediators as professionals and lawyers and everyone who has joined us, and we will hold special masterclasses and euro drawing in order to support your internal resources, because mediation is a sphere that works with humans, and it's important to maintain your internal energy. I'd like to thank the partners, colleagues, friends for joining, taking active part. I thank the European Union especially because the EU has been supporting this event very actively through projects like Pravo-Justice, for instance, that has been developing systemically mediation. And the concept project that was launched in 2022 allows, even during the war, to further develop this sphere of peaceful settlement in Ukraine. I would also like to thank the Ukrainian team, all the volunteers who have actively participated in organizing the forum, taking care of all the logistics and the technical side of things. And most importantly, we would like to thank the defenders, the Ukrainian warriors who are making this possible for us. And there is a special program of the Academy for the veterans. It makes it possible for the veterans of Ukrainian armed forces to go through a special training, mediation training. It's free of charge to them. And we already have some veterans who are interested, those who want to get a new profession, those who can improve their communication skills. This is our way to say thank you to them. Okay, in that case, we can now begin our forum in earnest. We will start by considering mediation in global strategies and national strategies. It will unite Ukrainian organs of government, other nations, international organizations, and this is where we discuss the role of mediation in national and international contexts, as well as the planned steps to uh, to improve mediation. Roman Babiy, member of parliament, member of the legal policy committee in the parliament, is with us today. He will be one of our presenters. Mr. Jokubauskas, who is Deputy Minister of Justice in Lithuania, Olena Bilokon, Judge of Supreme Court of Ukraine,
Oleksandr
Banchuk, Deputy Minister of Justice of Ukraine, Andrii Ovsiienko, representative of Ombudsman of Ukraine, also representing Ukraine in Constitutional Court of Ukraine, Alistair Simon Chetty, Senior Assistant to Director of International Legal of Minister of Law in Singapore, Arne Kinnunen, Senior Advisor from the Ministry of Justice in Finland, Silver Baffy. Selection of panelists today. We are going to have interesting discussion. And the first presenter I'd like to give the floor is Mr. Roman Babiy, head of the Legal Policy Committee of the Ukrainian Parliament. We know that the committee did a lot of important steps and initiatives in order to develop mediation in Ukraine. Perhaps you have some tips and pieces of advice for us as well. Hello, Luiza, thank you. Let me start my presentation by thanking the organizers, the Ukrainian Academy of Mediation, Pravo-Justice and Consent projects for your systemic support to this important event. I would also like to point out the scale of this event, because we can see that the attendance is growing. We have more and more participants and very interesting panelists. Regarding the topic, in my understanding, in order to effectively achieve result in a certain process, we need to clearly understand where we stand today and our ultimate goal. Where do we see ourselves in the future? Only after that can we map the route and make sure we get there safely and effectively. Now, to identify the starting point, the intermediate point, and the final point, last year we had 2-day parliamentary hearings dedicated to mediation. These were 2-day hearings, and 1 day was dedicated to mediation. And The results were quite interesting, and it is fairly symbolic that a few days after the forum, in 2024, on the 31st of June, we approved our recommendations. So I'd like to briefly remind you of what the committee recommended to do in mediation. It was recommended to introduce changes to procedural code of Ukraine, civil code of Ukraine, in order to make the process mandatory for cases that flow out of contracts where a mediation agreement was signed. Regarding the Cabinet of Ministers, Ministry of Economy also recommended to have mediation envisaged in PPP contracts, other economic contracts, as one of the options to settle disputes. Also, Cabinet of Ministers of Ukraine recommended to create interagency council in order to develop alternative ways of dispute settlement. And it was recommended to introduce changes to a number of enabling legislations.
Рекомендації відповідних були реалізовані. Було рекомендовано розробити зміни до
закону. It was also recommended to introduce changes into envisage mediation in court ruling enforcement. This first and foremost concerns consumer disputes.
Про врегулювання спору за участю судді та медіації. Ну, от, власне, якщо коротко, то
These are briefly all the recommendations. If you want all the details, of course, they are available in open sources. Now, I'd like to talk a little bit about what the Parliament can do in order to improve the situation and further develop mediation. So within our committee and subcommittee work, we held out communication events in different forms, such as work meetings, roundtable discussions. Some meetings were dedicated to collection of statistical data in mediation and other sources involving ministries, experts. Of course, it's not a simple solution, and it requires quite a lot of efforts from the government bodies, as well as unified approaches.
Actually, one of the panel discussions within this forum is dedicated to the figures and statistics for mediation. And it's interesting to learn more about how it works. As a result of these discussions, we have amended the reporting practices for courts that report to the state judicial administration. And therefore, we're going to collect data from the courts for this year. This is going to be statistical data on how trial reconciliations are handled, how the proceedings happen within the amicable dispute resolution, including mediation. So I think this statistic will be very important for mediation practitioners, because we are now focusing on ADR, and with the support of the EU-led consent project, we have done the roundtable discussion dedicated to amicable dispute resolution, and we have discussed the roadmap on the EU accession, it was wondering to hear from the Minister of Justice how institutions implement ADR within their roadmaps for European integration. This is an ongoing project. We could ask questions and listen to some of the fundamental discussions, studies, and researches on pre-trial proceedings. We have discussed as well the issues of mediation in the framework of the overall justice developments. And altogether, we had discussed, well, it was like a meeting, but we had discussed a coordination framework for ADR. Again, this is part of the committee's recommendations, and we've been talking about the establishment of the International Council on this, and this was a #1 recommendation for the cabinet. We had a lengthy discussion about this, a very interesting one as well, on which format has to apply here. We have included so many options like Ministry of Justice, Cabinet of Ministers, Office of the President, and many other institutions. As a result of this discussion, we have come to a conclusion that the most efficient way is to create the center within the cabinet. I perceive that this format has the buy-in from Olga Stefanishina, the Vice Prime Minister. It has been endorsed by the cabinet committees, and I think the Ministry of Justice will share more insights on this. It can be an impression that I listed so many things that can be bluntly about talking, but we are trying to walk the talk. I'm convinced this is not true, that we're not just talking. I would call this format as one of the ways of the parliamentary control, because our committee and subcommittees have been engaging so many stakeholders, government agencies, and these things always promote government agencies to push forward all those recommendations and make them more efficient once implemented. And here, I would like to thank the mediators community and the Ukrainian Academy of Mediation, Luiza Romanadze, namely for monitoring these processes and being engaged in these processes, because you have been highlighting all these processes that are underway. They are important for further mediation developments in Ukraine. Overall, all these things that I'm talking about right now are formalized through communications, different events, roundtable discussions, applications from mediators and arbitration communities. They have been so convincing that the Institutional Coordination Center, the ADR Center, has been so far very important. And I would highlight this as a very good advice and one of the most important recommendations, so that we can, as soon as possible, make sure it works so that the stakeholders are aware where to go to once they have anything to share or anything to discuss with us. They can find the right communication channel. Just briefly, I'm just going to borrow a couple of minutes from the timeline. Regarding the legislative work, I hope I can do that. Can I? Yeah, you can have 2 minutes and no more, please. Thank you. Indeed. So regarding, honestly speaking, within the recommendations context, it's very difficult to talk about breakthroughs, but nevertheless, we're talking about on an ongoing work. I've already mentioned the Ministry of Justice's hard work on pretrial mediation and the need to improve building court annexed mediation. I'm sure this is something that we have to do right now. With only one spot solution, one cannot do that. With only draft legislations, one cannot push this forward. Not through the changes individually, one can handle all this framework, but this has to be a holistic approach, the comprehensive thing about amending the legislation that will help improving and intervening mediation into the system of justice. Right now, there is a lot of correctional work that we're happy to do and deal with. Right now, we have to consult with the Ministry of Justice on these matters. The Ministry of Economy, as you know, developed the framework about different property-related disputes, and they push forward those pretrial proceedings, including mediation. Just recently in May, at the beginning of June, this bill has passed the first discussion in the parliamentary committee. Hopefully, with the amendments, it's going to be pushed forward as the bill to the parliament. Hopefully, it's going to be the registered draft law on the consumer protection legislation, whether it is about the labor mediation or any other areas. So this draft law is right now recommended by the subject matter committee to be adopted in the first reading, at least, already this year. So, summing up, I'd like to say that by evaluating this legislative work and frameworks, we should all be reminded that, of course, we have to be mindful of distributing efforts and engaging stakeholders between the Ministry of Justice, the parliamentary and cabinet committees. Another priority is, of course, European integration. For our committee, for instance, this is the key priority, is to push forward the draft law on the judicial reform. But I'm convinced, and I've been supporting this message so far, that ADR must be an indivisible prerequisite of the justice reform agenda, because citizens always need to have an alternative dispute resolution mechanism, more amicable, more peaceful, through mediation, through negotiations, through other solutions apart from traditional legislative, I mean, not legislative, but proceedings, court proceedings. The more efficient ADR is, the more efficient the system of justice is going to be. It's not going to be overwhelmed. It's not going to be like overloaded. It's not going to have a lot of backload. It's creating additional opportunities for citizens and businesses to restore their rights. And I'm sure when developing strategies, global strategies, and implementing reforms, we have to be conscious about the importance of this. Thank you for your attention. Sorry for taking a little bit more time than you expected. Thank you very much, Roman. Thank you very much for this great intervention about what the committee has been doing. Actually, we highly appreciate your own engagement into mediation and into promoting this. We're going to come back to this with Mr. Banchuk about the coordination center, because this is a very important issue, and thank you for focusing your attention on this. Dear colleagues, do you have any questions to the speaker? If you have them, please leave them in the chat. We're going to share them with all our speakers. Whenever we have time after the panel discussion, we're going to be voicing them over. So let us move forward. And I would like now to move forward to the representatives of the judiciary. And it is my pleasure to give the floor to Olena Bilokon, the Justice of the Court of Cassation of the Supreme Court of Ukraine. Olena, we've been actively watching how the Supreme Court has been demonstrating its support to promoting mediation and disseminating information about mediation, both in courts as well as in the international arena, with the respective associations such as JAM, the European Justice Association for Mediation. What are the priorities right now of the Supreme Court so that mediation stops to be an exception but becomes real practice? This is what we want to talk about. And is there any capacity for closer cooperation between courts with mediators? Thank you. Thank you so much. Thank you, Oksana. I want to thank for the invitation. I want to welcome all the colleagues and greetings to all the participants of this activity. It is so nice to realize that I'm here speaking in front of the vast majority of the stakeholders on behalf of the Supreme Court. And I have so many hopes that we have fruitful discussion and borrow some of the international best practices in implementing mediation in the Ukrainian context. So regarding the Supreme Court's vision for mediation, the Justice Development Framework and Strategy recognizes mediation as one of the pillars for access to justice, investment attractiveness of Ukraine, and social productivity of our society. We have clear vision that a judge, a justice, when performing his or her job, when will be able to realize this huge mediation's potential and become a real tangible tool for conflict resolution. For the system of justice, like it was said, mediation has obvious advantages. Mediation can indeed reduce the backlog for the judiciary because the system of justice can not only give away some of the cases, but also handle some of the cases through pre-trial conflict resolution. Just give you an example. For that period of time, since we've had the law on mediation since 2022-23, if we assume that mediation serves 10% of family cases and inheritance 5%, then through mediation, one can handle around 35,000 cases over the last 2 years. This is an impressive figure. But with a number of backlog right now, we don't know how we can handle it through mediation. However, we have hopes. By the end of 2025, we're going to know the figures clearly. Because since 2025, we're going to have amendments to the court reporting framework, and the statistic will include the number of mediations, conciliations, conflict resolutions through courts. And so by the end of this year, we're going to know how much mediation will have been efficient in dispute resolution through ADR. However, apart from this simplistic approach for the courts, like to reduce the backlog, it is important to consider how democratic procedures can actually be handled through mediation, how professional judges and justices can be attracted through the system of amicable dispute resolution. I know I only have 10 minutes, but I cannot help sharing this. Together with our colleagues, we went to the Podil Theater, and Franz Kafka and his theatrical works have shown how comfortable an individual can be when not confronting the system of justice sometimes. Of course, we cannot find the right balance in the most sophisticated and difficult cases properly. A judge of integrity may not sometimes understand what mediation really is, but through amicable dispute resolution, this can be shown to everyone how this can be handled. And with the Supreme Court justices, we've had a number of events and activities on mediation. And on the second anniversary of the Ukraine's mediation law, the Supreme Court had done the roundtable discussion, judiciary and mediation. Over the last three years, our justices have taken part in the national, international, interprofessional conferences, both in online and offline formats, regarding handling labor and family cases. The ultimate goal is to strengthen institutional and professional connections between mediators, lawyers, psychologists, other experts that happen to deal with amicable dispute resolution through mediation practices. Judicial procedures for family conflicts do not always highlight some of the specificities of these conflicts. And regarding children, minors, sometimes practices are not sufficient. That's why family cases require more mediation. And for instance, right now, training for judges is pending that are considering family cases, and there is training on mediation, on dispute resolution with the participation of a judge. This initiative has been implemented through the agreement or memorandum of understanding between the Supreme Court and our international partners. We are fostering developments of efficient mechanisms and ADR as efficient mechanisms for dispute resolution. We are promoting mediation in administrative justice at the respective level. So the active opinion of the judges manifests the importance of introducing and implementing mediation on a proper level. And we consider mediators as the state-of-the-art practitioners for conflict resolution through the negotiations. And like Oksana has mentioned, we have international partnership. We have signed MOU with the European Association of Mediation Judges. And we are trying to push forward European standards, which is a state-of-the-art step in the context of Ukraine's integration to the EU. As we all know, the court can only talk with the society through its decisions, and with its procedural activities, we're trying to push forward and promote mediation whenever we administer justice. It's good to notice that we have the procedural framework, and with the adoption of the mediation law in Ukraine, we try to build awareness among judges that mediation can be one of the solutions to resolve disputes. But at the same time, we have to be mindful that an individual should not have an opportunity to take advantage of litigations to achieve his or her ultimate goal. So that's why whenever we explain pre-trial practices and ADR, we always make an emphasis on the fact that if an amicable resolution is not possible, one can always come back to litigating with the same reasoning, with the same access to justice, and you're going to have all the rights abided by. Procedural activities of the judges through mediation acquires very broad popularity. The CPCs and procedural codes can help alternate procedure once the parties want to move for mediation. But not only the first and second instances courts, even the cassation court has already such cases. There is a cassation commercial code when the proceeding was stopped by the cassation court of cassation, I'm sorry, just because the parties wanted to get involved in mediation. Therefore, amicable resolution can be reached through alternative mechanisms, and this Supreme Court's practice can be really fruitful. And the other courts, I mean the lower instances courts, will probably follow the same practice. Of course, the efficient awareness raising about mediation can largely depend on whether the courts have enough knowledge about mediation. Ukraine's judges and justices since 2017 have been applying such a procedure as the litigation-led conflict or dispute resolution like it works in the EU, and this is one of the ways to make mediation more institutionalized. So training for mediation practitioners has been really important, and it would be important to cover judges as well, because apart from the judge's main job, he or she can be a real case manager, like the one who can manage those cases. And the status will oblige him or her to be able to hear actively and listen, to listen to both parties, be able to analyze information, sum up all the information. And that is why a judge or justice in his or her professional activity can often be not involved in direct roles, but alter for or opt for amicable resolutions. And right now, our justices have been taking very active part in mediation activities. And since 2019, we've been actively involved in training processes regarding mediation, because judges have to understand what's the difference between litigation versus mediation, know what the parties can do or cannot, know how to identify those cases who are best fit mediation, etc. That is why we as justices understand the importance of this training for professional growth. Some of us have been handling this through their own resources. So to be able to know
In order to understand where we stand today, we conducted polling in order to understand better how many judges went through mediation training. We circulated it among the various courts, and this is an attempt to understand better to what degree judges are learning mediation and how they can inform others about mediation, how to settle disputes involving the judge. There is a need to raise awareness about mediation and how the court community can help with this. I'm glad to say that thanks to effective cooperation of the judiciary with the mediation community, we've made some real steps. At the court official, the judiciary website, there is a special section dedicated to mediation, and every court has that. There is a tab mediation for dispute settlement that includes several banners that gives a lot of information, clearly stating the key concepts and opportunities that mediation offers. It explains who mediator is, what role he plays, how mediation is related to the judiciary hearing, and also there are some tips and recommendations on how to find a mediator. Also in courts, we have information about mediation experts. In conclusion, I'd like to say that the vision of Supreme Court with respect to development of mediation, it's a priority. Judges in their activities more and more often look at mediation as one of the options, and they implement in their work the best practices that can be borrowed and gleaned from mediation. The quality of life is not about not having conflicts, but how we can settle them. Thank you, Olena, for telling us, updating us on the latest developments in Supreme Court. Thank you for your contribution toward developing mediation. Now I'd like to give the floor to Andrii. Is Andrii online with us? Yes, I'm here. Yes, I can hear you.
Знову ж таки, приємно, що ви сьогодні представляєте Офіс омбудсмена на цьому
We are glad that you represent the Office of Ombudsman here. I know that you personally have been involved in developing mediation in the judiciary, and now even the office is involved in these processes. Could you please tell us a bit more about the role of mediation in human rights protection, and why does it matter to the Ombudsman? Hello, Luiza, dear organizers, dear participants. On behalf of the Ombudsman of Ukraine, I welcome you all. Despite difficulties of martial law, we continue to use mediation, and indeed, we have Article 55 of the Constitution, which guarantees protection of in any legal way. And when the law on mediation came into effect, it identified the principles of mediation, the status. It covers civilian, administrative cases, and misdemeanors. Mediation was also implemented in the procedural industry. Land code was amended to that effect. So we can say today that mediation today is in line with the EU requirements. Now, the availability of mediation, prevention of escalation, and international standards adherence states that mediation is underrated tool of human rights protection. This forms the constitutional foundation for the Ombudsman. I'd like to tell you a little bit about the mandate of the Ombudsman. There's a special law on Ombudsman of Ukraine, and Ombudsman in Ukraine carries out parliamentary supervision over the freedoms of Ukraine. It considers complaints coming from the public on the actions or omissions of the government, and it supports dispute settlement. So mediation as a voluntary procedure complements the tools available to ombudsmen, and international experience clearly shows that many European nations actively use mediation in order to settle disputes between governments and organs, between the citizens, the people, and organs of government. The Ombudsman can initiate mediation between a plaintiff and the organ of government, and using actively mediation, this can objectively improve effectiveness of the Ombudsman. This is especially true for healthcare, complaints, education, social sphere, and this leads to a satisfactory result which shies away from the bailiffs and forceful enforcement. Mediation can be used also as a tool for negotiation with the government and restore the rights of the citizens. Also, Ombudsman's activity involves protection of rights of inmates in prisons and generally in places of deprivation of liberty. For example, we look into cases of complaints in prisons, psychiatric hospitals, and mediation can help find solutions and minimize conflicts and prevent escalation of conflict. Next element is settling conflicts in communities. Therefore, mediation can be broadly used in conflicts involving, for example, IDPs, veterans, ethnic minorities, public activists, and I think mediation as a tool of transitionary justice can objectively help us to restore national trust in the society and tackle a whole range of other conflicts at the national level. Mediation can be used in order to solve issues of rehabilitation, returning property, assets. Therefore, mediation is a naturally complements the work of ombudsman because it helps to restore rights quickly without escalation. It enhances the trust for government institutions and reduces the pressure on the judiciary, and the workload in the judiciary is quite high. So, in my opinion, mediation has significant prospects and advantages, and including mediation into a model of responding to complaints can improve the process of considering, looking into complaints, analyzing them, and then using mediation techniques, we can achieve the more acceptable result, which will satisfy the plaintiff and will restore the rights of the people. It is also important to improve communication with the citizens, and mediation is a great tool to do just that. Finally, Ombudsman, as an important national institution, has the opportunity to further promote mediation as a tool of interaction between the government and the people. Therefore, mediation as a system of restoring people's rights, it is conducive to the dialogue of tolerance in the society. And it's a more humane way of conflict settlement. All we need to do is to take other legislative steps in order to make mediation more enshrined in the existing legal framework, and of course learn from international experience and improve the quality of these processes. This requires, of course, political will as well as interagency cooperation, and as well as changes needed. And today's event shows that we do enjoy international support, and the audience today and tomorrow will show us that this is indeed the case. We have thousands of participants from across the globe. Thank you for your attention. Thank you, Andrii, for describing the role of ombudsman and how this is related to mediation. It is great that you see so much opportunity to use mediation in various aspects. And also at the end, you mentioned interagency cooperation. Therefore, now I'd like to give the floor to the Deputy Minister of Justice of Ukraine, Andrii Banchuk. Ministry of Justice has been working on introduction of mediation in legal aid processes, and you were actively involved in developing a roadmap. Could you please tell us what the agenda is for today, what your plans are, and if you could tell us about the status of the interagency coordination and the role of the government? Thank you. Hello. I welcome all the participants.
Коли ми беремо участь і в заходах онлайн, бачу таку кількість одночасно онлайн.
Actually, it is the first time that I see such a huge number of participants in an online conference.
Так, хочуть, але ми не зупинимося. Я хотів би, звичайно, зреагувати таким чином, що сподіваюся, що чути видно мене все-таки нормально, да?
Добре.
Да, дякую за вашу оцінку про те,
Thank you for speaking so highly of the work of the ministry and the activities that we currently undertake. But it is also true that our activities and our work is not enough. Why? Because the potential of mediation is not fully unlocked in Ukraine. It's not realized. And events like today's, for instance, certainly helps significantly to improve the situation. But what I have to admit is that the ministry is not doing enough in order to raise the significance of mediation in Ukraine and its popularity. Now, the first thing I'd like to mention is that the report on the enforcement of the law on mediation, this is important because the law on law development envisages monitoring of enforcement of laws, and we involved all stakeholders and we trying to follow how various laws are being enforced, and in this monitoring we have more institutional issues. What is lacking for the law on mediation to work? Because there are no procedural issues.
That is why this is one of the things that I'd like to mention. This is regarding the fact that the law and its monitoring, how it applies. This is what the ministry has been doing so far. The second pillar, this is a comprehensive thing in the context of the European integration, and this is really important. And this has been mentioned already by Manfredas remind us, the European Commission's representatives, that the roadmap in the rule of law mentions one of the goals about the need for proper extrajudicial conflict resolution. Under this objective, we have 5 different activities that we have to implement throughout 2025-27. Namely, those are things that are focused on awareness raising about mediation. This is training on mediation, data collection. This is also something that gets mentioned. We need to monitor how mediation is enforced. And one of the activities actually is related, as part of the roadmap, is related to arbitration developments. It is also important to mention here that alternative dispute resolution developments are reflected in the rule of law roadmap, which is a kind of a guideline and an important ingredient for the first cluster in our accession negotiations. Practically, these law implementation has been handled through the legal aid framework. Respectively, we have a pilot project for restorative conciliation. It has to do with minor offenders who are suspected of committing crimes. And for those particular cases, this program, as it has been endorsed and confirmed by the Ministry of Justice, Ministry of Interior, and General Prosecutor's Office, it envisages once such a crime is identified where a suspect is a minor, we need to mandatorily engage a mediator, because this is needed for both the offender and the victim. It should be mentioned that we launched this pilot project at the expense of UNICEF, who is our international partner, and this has been probably the first practice ever. Maybe correct me if I'm wrong, but since September 2024, we started the new phase of this project, and we are running payments for mediator services from the Ukraine's state budget. Naturally, this is not the full-fledged pay that other proceeding actors would engage and enjoy. But this is still very important, that under martial law, under all the limitations, we still allocated funds from the state budget to engage mediators. In our mediators register, as part of the legal aid, we have 182 mediators, and we already have outcomes. We clearly know that roughly as of the 1st of June, we had mediation and resolution requests through restorative conciliation for minor offenders. The number is 170, and right now we have already 70 judgments. And now the courts decide whether this is going to be a decision on closing the case or the sentencing solution. So our colleague from the justice from the Supreme Court has been mentioning the importance of mediation, but through this pilot project, we are now talking that not only those suspects, minor offenders, I mean, can have practiced those, not them, but against them or in favor of them, we want to practice mediation. So we want to monitor this pilot project outcomes and try to build, therefore, the infrastructure so at least in this part, we can actually already enforce the law. And summing up my intervention, this is probably one of the most important issues. We need to create platforms for alternative dispute resolution mechanisms. Like it was mentioned by Mr. Babiy at the very beginning of our session today, that indeed the committee hearing recommendation was there, and we perceived this recommendation and accepted it. And on June 25th, yesterday, actually, after the endorsements took place between the respective ministries, the draft resolution on setting the Interdepartmental Amicable Resolution Committee has been sent to the Cabinet of Ministers for its consideration. The internal endorsement is there, but we need to follow all the internal procedures and get all the approvals from the committee. And therefore, we have the resolution and the tentative composition of the Coordination Council. So we're going to hope that we not only engage central government agency representatives, but also other actors. There is possible, once endorsed, the participation of mediators, members of parliament, judiciary representatives, but once endorsed, because this is the government resolution. Hopefully, in the nearest future, it is going to be improved by the government. We believe that this is going to be an incentive for further developments in the mediation. This is going to be the platform that is going to be actively working on this matter. So this is, I can see that my time is running away. So let me thank you for your attention, and thank you to all the organizers for having set up this activity. Hopefully, with so many participants, over 500, we can discuss this on a professional level, get together and discuss so many important things. Thank you so much, Oleksandr. Actually, I think that we have a lot of things that we can share. We want and dream about the same things. Hopefully, we're going to have a one-on-one meeting very soon, because with Luiza and I, when we're sitting together and talking and planning the fora like this, I can see that this is a great opportunity. Of course, once we're having meetings online, it's always best to meet in person. Thank you very much, Oleksandr, for sharing some of the plans on the interdepartmental coordination, meetings and efforts. And thank you for the developments in terms of mediation and pushing forward the law on mediation. I want to thank you for introducing the plans and the outcomes of the Ministry of Justice's work. Right now, let us move to our next speaker, Mr. Rytis Jokubauskas. This is our Lithuanian colleague. We have been working for so many years with Rytis on the bar reform right now. Rytis represents the Ministry of Justice of Lithuania, and we would like to hear more about mediation developments. Mr. Rytis, we all know that mediation in Lithuania has been progressing for so many years and has been integrated in the system of justice. What have been the success factors of mediation's progress, and what has to be useful for the Ukrainian case in terms of further mediation development? What are the success stories and maybe success recipes for successful implementation of mediation in our country? Thank you.
Hello, everyone. Nice to be here in this meeting. Well, if to give a short answer to the question, what is the recipe for success? It's very simple. It's hard and consistent work. So there are no miracles, no golden bullet. You simply have to work consistently and do your best to promote mediation. Also, short remark to the previous speaker, my colleague Oleksandr, about the potential of mediation that is not fully unlocked. We in Lithuania, we are still unlocking it. So we are still in the process. So I believe that this potential is such huge that you should not see it as something that's, achievable and then you can forget it. It's an ongoing process, and you have to keep on doing it all the time. Now to go very briefly over how did mediation expanded in Lithuania. Well, we started to promote it in a more consistent and manner 20 years ago, in 2005, when we started a pilot project with judicial mediation in one of the courts. And then in 2008, we introduced the law on mediation, and that was just the beginning. Then in 2015, we introduced judicial mediation in courts of general competence. In 2019, we introduced judicial mediation in administrative cases. So it was not done in one step. It was moving gradually. In 2019, we introduced the list of mediators, which already meant that not everyone could be a mediator, and you had to comply to specific requirements in order to be a mediator. And that was strictened on the way. There was also self-governments of mediators created, code of conduct for mediators that they have to apply, and so on. Currently in Lithuania, we have over 600 mediators, and out of them, over 100 are judges. So the involvement of judiciary is also very important, that judges at the same time could be mediators. But also it means that it's not only judges, majority are not judges, and it's lawyers, psychologists, sometimes even social workers. So there are all sorts of professions within the list of mediators. Usually they have to do something with the legal procedures. For example, some people from Patent Bureau are also on the list of mediators. Also, when we moved gradually with the introduction of mediation into legal system of Lithuania, in 2020, we already introduced mandatory mediation. Mandatory mediation was in two cases. First of all, the family disputes. That was identified as the type of cases where mediation might be the most effective and most productive. And also another type is freedom for the judge to decide whenever the judge sees that in that case it might be possible to come to an amicable solution, then the judge can order mandatory mediation in any civil case. So last year, out of mandatory mediations, we had over 4,000 mandatory mediations in cases, and roughly 50% of them ended in settlement agreements, which means that 50% of all those cases did not move along in the court system. And it does not mean just that case ended with a peaceful settlement. It also meant that there was no appeal, so there was no burden on the court system with all those cases. And we keep on moving in introducing this mediation also in outside of civil cases. Now we have already started the same thing with administrative cases. Again, although the numbers are much smaller, but especially in pre-court procedures, when mediation is applied, also we see that roughly around 50% of cases end up in peaceful settlement, which is, I think, a very good number. So now, if to look at potential and further steps that Lithuania is doing, besides the introduction of civil and administrative cases, we already have in the plan of current government the introduction of mediation in criminal cases. So how it will look like, it's a little bit difficult to say now because it's still work in process. We are planning to have the draft vision probably next year, but that's the direction we are moving forward. And I believe that we are not stopping there. There's going to be plenty more room for implementing mediation, and I'm very glad to hear that Ukraine is also following this path. So thank you, and I would be glad to answer any questions.
Щиро дякую, пане
Thank you
Rytis,
so much, Rytis, for sharing Lithuanians' experience and best practices with us. Thank you for sharing this big share. I'm sorry for saying shares at the same time, the 50%. This is a great model. Certainly, we're going to be coming back to you on these things that we're trying to push forward in Ukraine. And right now, let me give the floor to Andrii. Andrii Kinnunen represents here government of Finland, namely the Ministry of Justice. And we know that you have been the driver of mediation developments at the Ministry of Justice in Finland. We're also aware that there is bilateral cooperation with our Ministry of Justice as well. So please, if you can share a bit more about the Finnish best practice and the development model for mediation. What are the tools, what the ministry has been doing, and what are the conclusions that could be helpful for Ukraine as well? Thank you.
Thank you very much, Luiza and Oksana, for first of all, inviting me to speak on this very remarkable occasion you are having, and also congratulations to the Mediation Academy of Ukraine. This is really a spectacular event with so many participants and very established speakers. I'm very proud of that and proud to see in Ukraine having mediation and restorative justice in the agenda of development of justice system within Ukraine, and especially taking into account of difficult times your country is having, and my duly respect for the population of Ukraine, and especially of those who are in the front line of protecting your country. As your title of the panel mentioned, global strategies, I thought of starting with those because it's very important also to take into account the kind of global movement we have within the mediation and restorative justice. As I see it, it started perhaps from the United States and many European countries already in the 60s and 70s, taking into account the difficulties the justice systems have, and difficulties of people for access to justice, and also the justice system was not capable of reflecting what people really need when they try to get justice. When they try to get justice, it's not only justice in material sense. Justice is also to giving people the understanding that they are being treated respectfully of other persons, but also for the government, also for the justice system. And traditional justice system is perhaps not doing that in the best way. And it was seen important to develop an alternative way to achieve justice, to give a possibility for people to achieve justice and be, as Niels Christie very intelligently showed out from scholar from Norway that it is a kind of a property we have. Conflicts are our property, and we have their possibility to learn and possibility to discuss and motivation for change and getting forward. That's why mediation is such a noble way of trying to resolve conflicts. And I'm really proud that also Ukraine is on that path, and then really interesting to hear experience from Lithuania as well. The global standards has been developed since 19th already in Finland. We see that Council of Europe recommendation of ministers from 99 mediation in penal matter was a kind of a path-breaking document, and it has been altered in 2018 in a new version of that, and even the ministers came up just a couple of years ago with the Venice Declaration, even more emphasis the importance of mediation. Also, United Nations has been very interested in crime issues. The Commission of Crime Prevention and Criminal Justice has come up with several resolutions concerning restorative justice. Basic principles on restorative justice dates already from 2002, and they are still valid document. European Union, of course, as was mentioned in the opening speech of this panel, of this seminar, has been more and more interested in this. I would like to mention the EU Directive on Civil and Commercial Mediation from 2008. And now then, of course, the Victims Directive that gives responsibility for the member states to organize mediation for the victims of crime, if they so need. This is all about, as we see, the previous speakers have been talking about mandatory mediation. In Finland, we didn't go into that direction. We have very many applications of mediations, but none of them are mandatory. It's the free willingness of the participants, and it's kind of a core idea of all of our systems. But we have developed court mediation. I would say court mediation in civil cases, and especially follow mediation expert assisted court mediation takes place, where there's a social worker as an expert. This and then victim offender mediation are the two applications that enjoy really solid legal background and foundation, also state funding. And we see really these two are kind of a groundbreaking, I would say, rules for if you want to get the development in this issue, to have a really solid legislation and state funding. Without those two, I think all kind of a project type of mediation applications are really important. We have several of those, but if they are missing these two ground components, the success is probably not that going to happen that well. I would also like to mention restorative justice dialogue. We call them dialogue in prison and probation settings, where in serious crimes, where victims of crimes and offenders can meet and discuss. And this is, of course, after the court sentence. And we don't call that mediation because the language mediation can be a little bit misleading. It can give an impression that offenders are kind of left out from their responsibility. And we really try to guarantee that this is, in most cases, this is not taking place, that we still have a possibility for the full criminal justice proceedings, although the mediation takes place, because we value the possibility for victim and offender, and also in civil cases, both sides, to discuss the case, to find out the motivation of the other person, trying to find a common solution, try to restore the wrongdoings, and in that way try to give a possibility for people to better improve their lives in the future. Also, our bar association have a mediation service and training for that. We have very extensive school mediation taking place in schools. We call that peer mediations. So pupils are trained to be mediators, and they are mediating the conflicts between their colleague students. This is very kind of a promising way to teach children how to resolve conflicts by mediating them, by discussion, by trying to understand the starting point of another person. Street mediation is important in Finland. This takes place, for example, in shopping centers, and concerns stealing or violence or fights, things like that. And the mediators can help solve the conflicts there. We also have a neighborhood mediation and mediation, community mediation between ethnic groups. Working places have been also very interested about the mediation with the internal conflicts within the working place that, as you all know, takes place very often. Mediation is a very good way of trying to handle these situations. Our government after government have mentioned mediation in their government programs, and we have tried to step by step get forward in the mediation. In the mediation, also the government, we have a couple of words of the victim of the mediation. This is kind of would say a crown, jewel crown of our mediation system. We started that already in the 80s, beginning of 80s, with the experiment programs, and then got the legislation in 2006. It has expanded, and nowadays we have from 14 to 15,000 criminal cases per year mediated. We have about 100 professional in 17 mediation offices throughout the country, so giving out the service. And what I see has been really spectacular success is that we use volunteer mediators, and we have now 1,300 trained volunteer mediators in these 70 mediation offices, giving out the service without getting paid. They get their expenses reimbursed, but they don't get paid. But they are really in their whole soul giving out the service, and the mediators are from all spectrum of the society. They are students, they are law students, students of social welfare. There are people, retired people in whatever occupation, can be from the trade or engineers or whatever. But if they have soul in mediation, they are doing their work, of course, under observation of the professionals. Mediation in courts has been expanded also very nicely. We had our legislation in 2006, and also in courts, mediation is voluntary, and it's possible if parties so will, both parties and the judges are acting as a mediators in courts, and we call it like a facilitative mediation, that the court and the judges don't really make the decision there, but the parties make the decision themselves with the help of a judge. And important is that the agreement accepted by the parties may be confirmed as a court decision in the matter at the same time. So it is enforced, the mediation result is enforced in that way. We have around 8,000, 9,000 cases per year, or civil cases. Most of them, or I would say half of them at least, are family disputes. And this is really important way of giving families possibility to have a possibility to mediate, for example, from the custody of a child, or how to share the expenses of custody. This has been really important part of our mediation system in Finland, and it is still expanding. And We also have, I would like to mention our government program that takes really strong emphasis on youth crime, and especially on gang-related youth crime that has been seen as a problem in many countries nowadays. And we introduce kind of very severe legislative measures. Our kind of a current trend in criminal policy is a bit punitive. We use more and more criminal justice system. Our prisons are overcrowded, but still the government sees that mediation is one of the important ways also to deal with the youth crime and gang crime. Dear moderators, just a few words on the future steps. We see that we still have far to go to improve our mediation system. I would say that the mediation is not enough known in the general population. We have been tackling the issue how to make change to this, how to kind of give even more positive image to mediation, to make it well known throughout the population and make people believe that this is really the way to solve conflicts in very intelligent way, to put it that way. We try to be in contact with the media. Sometimes we succeed. Sometimes the media can turn against this idea. For example, in the case of the mediation in domestic violence, this has been a very difficult, hard issue for us, and now this government unfortunately has abandoned, and this is not possible anymore, the mediation in domestic violence, and this has given a little bit negative flavor to whole mediation process. But there's a lot to do to increase awareness of mediation, develop training, statistic. I would say very important is the uniform code of ethics of mediation. We need this kind of ethical work to do to kind of to build really solid ground for the process, mediation processes, and in a way that would build the trust for mediation and would improve the image also throughout the whole country. I would say this is it. This is it. Thank you very much, and once again,
thank you very much
for giving me a possibility to speak. Thank you.
Дякую, парне. Насправді дуже цінний досвід.
Thank you indeed. Finnish experience is very important for Ukraine. It is a great opportunity to see what works in your country and what doesn't. You especially stress the importance of government funding and need of training. This is something we can learn from you. And strategically, Finland is investing into mediation at schools. And in Ukraine, we're doing the same, by the way. So it's good to see, that we have someone who thinks alike and shares our ambitions. Okay, thank you. Now I'd like to give the floor to Alan Annister from Singapore. And I'd like to ask Mr. Chetty about how Singapore Convention on Mediation is used, and of course, how mediation in Singapore is used, what legal base you use. So please, Mr. Chetty, the floor is yours.
Thank you very much, Oksana, and thank you also to Luiza. Can I just check if everyone could see my screen properly? Okay, that's great. Thank you. A very good morning and afternoon, and also good evening to everyone. I would like to first express my thanks to the Ukrainian Academy of Mediation for inviting Singapore to participate in today's event. Of course, a huge congratulations to the Academy for the successful organization of this year's forum. Today, I'm very happy to share Singapore's experiences in how we developed the use of mediation in our country. I will first cover our perspectives on mediation generally, and then focus specifically on the use of mediation in international commercial disputes, particularly in the context of the Singapore Convention on Mediation. So very firstly, to just set the context, let me share Singapore's perspective on mediation. Developing mediation services and capability in Singapore has been a key aspect of our broader vision to serve as an international dispute resolution hub, one that offers a full suite of dispute resolution services. And this vision has informed our approach to implementing our obligations under the Singapore Convention. So we seek to offer a framework that is user-centric and one that complements our existing suite of services from litigation to arbitration and to mediation. This slide here provides a very quick snapshot of how mediation has developed in Singapore. Well, very firstly, the use of mediation has deep roots in Singaporean culture. It is embedded in practices of the main ethnic groups in Singapore. From the mid-1990s, Singapore introduced a national framework to promote ADR processes. And that came after recommendations from a high-level committee. Our courts then took a very significant first step in 1994 by introducing court-based mediation and incorporating ADR as an option in court processes. This strengthened the delivery of civil justice, improved the lives of our citizens, and also established the Singapore courts as a world-class judiciary. In 1997, we established the Singapore Mediation Center, which spearheaded the mediation movement in Singapore. And very shortly after, in 1998, we had a network of easily accessible community mediation centers, which was established to foster social cohesion. A couple of years later, in 2013, we explored ways to develop Singapore as a center for international commercial mediation. And this led to the launch of the Singapore International Mediation Center in 2014. Our Mediation Act came into operation in 2017, and that helpfully clarified and codified many legal aspects of the mediation process. And just 2 years after that, in 2019, we benefited from a significant development, which was the Singapore Convention on Mediation's signing ceremony that was held in 2019. And the convention then entered into force for us in 2020. So this brings me very quickly to the next segment of my presentation, which is the Singapore Convention on Mediation. Also known as the United Nations Convention on International Settlement Agreements Resulting from Mediation, the Singapore Convention is a multilateral treaty that provides an effective, efficient, and harmonized framework to enforce and invoke cross-border commercial mediated settlement agreements. So before the time where the Singapore Convention existed, there was no such multilateral treaty providing for this. And often it was cited that a major obstacle in the use of international mediation is really this lack of a legal framework. To explain this, Because a mediated settlement agreement only has a contractual effect, it may not offer as much assurance compared to other forms such as a judgment or an arbitral award. So from really a legal framework perspective, the Singapore Convention is really this missing third piece in international dispute resolution enforcement, joining the New York Convention for arbitration and the Hague Convention on choice of court agreements for litigation. All this just has enabled mediation to stand effectively on its own while complementing other forms of dispute resolution. After the Singapore Convention was completed and adopted by the UN, it opened for signature in 7 August 2019. And we were quite happy to know that it was the highest number of first-day signatories for a UN trade convention, where 46 countries signed the convention that day. As I mentioned earlier, the convention then entered into force in 2020, just 1 year after it opened for signature. And today we have 18 parties to the convention and 58 signatories. I just thought to share that it's been a very good progress so far. We have had 6 new parties just over the last 2 years. The SCM had entered into force for Japan, Nigeria, and Sri Lanka sometime last year. And then this year, we had Bahrain, Paraguay, and Costa Rica ratifying or acceding to the convention, which will then enter into force for them later this year. We've also had quite a number of public announcements from countries where there have been tangible and concrete developments. I do not have an exhaustive list, but I thought to share just a few. For Armenia, we understand that they intend to ratify soon, and they are undergoing processes to amend laws to streamline the mediation process of both commercial and investment disputes. For Brazil, we understand that the Brazilian Commission of Constitution and Justice has approved the convention, which would pave the way for Brazil's ratification. Colombia's Congress and Constitutional Court have also approved the ratification, and we understand that this development was primarily spurred by strong industry support. For the Kyrgyz Republic, they recently passed a draft law to accede to the Singapore Convention. And for the US, we understand that numerous US trade and bar associations have endorsed US's signatory and ratification. And quite recently, the US Uniform Law Commission had studied the treaty and how it would interact with the laws of the US. And that commission has endorsed the ratification as a self-executing treaty. Finally, Uzbekistan and several other countries like Brunei, Thailand, Malaysia, we understand that all these countries have been involved in legislative drafting processes so far and are taking other steps to move forward on the convention. So all my sharing is just to really show that, you know, when we ask countries why they are interested in the Singapore Convention, they usually give 3 key reasons. 1, it is good for businesses. So for example, 2 countries that are parties to the convention would enable their businesses there to know that if a dispute arises between them, mediation will be as good an option as arbitration or litigation. They will have certainty that any mediated settlement agreement can be enforced against the other in the other's home country. Second, we also understand that the convention helps attract investors. Mediation is an attractive avenue for investors who are wary of getting embroiled in litigation processes, and they are also wary of the cost of arbitration. So mediation, in our view, also provides a very cost-effective way of resolving disputes. Finally, the convention has been very good for states, especially those that have been involved in international commercial disputes. It shortens the process of resolving the dispute and avoids this idea of ascertaining a clear winner or loser, because that's often the last thing that a state wants to do. Very finally, to wrap up my presentation, I know I have about 40 seconds left. I thought to just highlight that one important platform that Singapore has to engage countries, both their government officials and also industry representatives on mediation, has been the Singapore Convention Week. And the Singapore Ministry of Law has been organizing this annually since 2021. And we're just happy to share that this year's SC Week will feature fresh perspectives from new partners and new programs that would discuss latest issues impacting the field of international dispute resolution. So please feel free to check out the web link. And this wraps up my presentation, and I'll be happy to receive any questions if you have any. Thank you very much.
Дякую, дякую.
Thank you so much, Alistair. Actually, whenever there are questions, people can text them in the chat. We will save them, and maybe we can give the answers a bit later. I want to thank you for inspiring us and immersing us into Singapore's mediation developments. And thank you for mentioning the convention. Ukraine was one of the countries who have joined this solemn signature procedure in Singapore. And we keep track on how the convention has been implemented and will be implemented over the years. And we've been discussing this for so many times. We had a separate, dedicated panel discussion in engaging countries that are signatories, as well as those aspiring for it. So now we have much more context about this. This is a really important convention. When we were talking about this international convention, let me go forward and move to Mr. Sylvie. Let me tell you that it is hard to overestimate mediation in labor relationships. We can see how strong ILO has been supporting mediation internationally through the training center which you have in Torino. And if you can tell us a bit more about mediation and its place in the ILO's framework and its engagement, and maybe a little bit about some of the things that have to be taken into consideration for Ukraine and other nations as well.
Thanks very much, and greetings from Torino, Italy. I work at the International Training Center of the ILO, which is a training center of the International Labour Organization. So thanks very much for the invitation. I think it's great to see more than 500 people online to talk about mediations, to reflect on mediation. I think that demonstrates the interest, maybe the hope that we have in terms of how we can better solve disputes. And maybe I would like to touch a bit of some aspects of conciliation, mediation of labor disputes in the context of labor disputes in a few minutes. So before I start, I'd just like to say a few words about the ILO, which is a specialized agency of the United Nations, and a specialized agency with a unique features because it's a tripartite agency, which means that the ILO is not made only of government representative, but it's made of a government representative, employers representative, and workers representative. That's very important in the spheres in the sphere of labor, because obviously that gives a special legitimacy And anything that is done at the level of the ILO, including the adoption of standards, is made in consultations and negotiation with employees and workers' representatives. And that's specifically very important for us when we talk about conciliation and mediation. So I think it's great, it's good, it's important to remember that before we talk about what the ILO does, we remember that this organization is made on an equal footing of employers, workers, and representative employers, workers, and government representatives from all different countries of the world. It's the questions of conciliation and mediation of labor disputes has always been a topic that has been of key interest for the ILO and for its constituents. There's a number of standards of international labor conventions that deal in some way with conciliation, mediation of labor disputes. And I would like to stress an important fact, a recent fact, is that in 2025, in early 2025, there's been a tripartite meeting at the ILO on access to labor justice for all, on the prevention and resolution of labor disputes. This tripartite technical meeting was convened at the ILO. I've just put the link on the chat where everybody can access the different documents that were prepared by the office in respect of this technical meeting. That includes a paper on access to labor justice. So it looks at conciliation and mediation. It also looks at adjudication or other ways to deal with disputes. But I think that if you are interested to get a comparative overview or understanding of what are the trends worldwide, or if you have an understanding to understand what are some of the challenges that labor disputes resolutions and prevention is facing, I think that the background report will give you a very strong idea, a very good idea of what are the different global challenges, not only in Ukraine, but in different countries with different kind of economic development of what are the challenges associated with access to labor justice. If you go to this webpage, you will be also able to access, it's only in English, French, and Spanish, but also a number of standards and a number of provisions in international instruments like ILO conventions and recommendations that are related to the administrations of justice. And some of these standards look specifically at conciliation and mediation, so that's important. And I would also like to say, and I'm gonna on this same link you can access what has been the resolution of the meeting and what has been the call for employers, workers, and government representatives when it comes to access to labor justice. And that call includes for the office, for the secretariat of the organization, to continue promoting the effective institutions for dispute prevention and resolution in line with some principles of effectiveness that you can find on the document. So there is work that is done at the level of the office. There is a lot of work that is also done at the level of the training center of the ILO. And I think that it was, I've been listening very carefully to all the different resource persons, discussants, panelists today. And I was very much interested to listen and to hear from them about what they're doing when it comes to training and when it comes to sensitization. I think that the Finnish example that there is some training at school is also very interesting. I remember some ILO training projects in Albania that was trying to support dialogue and support conciliation and mediation at the level of the schools, with the idea that we need to educate young people to be able to discuss, to be able to handle disputes by themselves, and that they should see the value of consensus-based solutions from their younger age before they become an adult and before they enter the workforce. And at the level of the International Training Center of the ILO, we are obviously very much interested to promote the capacities of conciliators, mediators, employers, and workers to handle disputes by themselves and not rely on adjudications to deal with disputes. I've just shared a link on the chat, which is our free of charge online training course on conciliation and mediation of labor disputes, which is on the eCampus of the ITC-ILO. It's part of the effort of the ILO to make sure that we've got more and more people that feel I understand the basis of conciliation, mediation of labor disputes. This training was conceived with the support of the government of Canada, and we've been launching it a few months ago, and we've already more than 1,000 people that completed the course and received an ITCILO certificate on conciliation mediation of labor disputes. So there are tools. And I'm also very pleased to inform that very recently we've been convening at the ITCILO a certification course for the National Mediation and Conciliation Service of Ukraine, where we've been not only training conciliation and mediation from the National Mediation and Conciliation Service, but we've also been supporting in certifying their competency. So there is a world of work to do to assess, to recognize the skills of those that are engaged into labor disputes. And I believe that at the ITCILO, we are trying to provide some up-to-date and effective solutions for recognizing the skills of those that are handling the skills. In the context of labors, there are many advantages, and conciliation and mediation is providing a lot of benefits to the parties. I would like maybe, after listening to the different panelists, I'd just maybe like to highlight some of the advantages and some of the benefits of conciliation mediation that have a special interest when it comes to the specific sphere of labor, whether it's individual labor disputes or it's collective labor disputes. The first one that comes to my mind, and having worked for more than 20 years in different countries on the aspects of access to labor justice and the aspects of dispute prevention and resolution, is the fundamental aspects of the employment dispute, which is a question of the relationship between the parties, between the contentious parties, whether it's individual, but even more importantly, when it's a collective dispute, the question of the relationships between employers of employers organizations and trade unions or group of trade unions is critical, and it goes much beyond what is the actual dispute at stakes. So having mechanisms where the relationships between employers and workers' organizations can not only be preserved, but can be strengthened is fundamental if we want to get long-lasting social dialogue and relationship between the parties. Because in an employment relationship, or especially in collective disputes, the relationship between employers and workers organizations will remain even after the dispute has been settled. So conciliation mediations and amicable dispute resolution systems provide employers and workers with the capacity to preserve their relationship, because their relationship will not end with the dispute. If you have a trade union in your company, or if you trade union your company, you're going to continue negotiating with them even after the dispute. So I think that the question of the relationship among the parties is a critical benefit of conciliation and mediations when it comes to dispute resolution. It has been mentioned, but I think that's extremely important in the context of labor, is the questions of cost effectiveness. Getting employers and workers that can handle and that can receive support without disbursement of amount of money or getting too much trapped into the judicial system is fundamental if we want employers and workers to get a productive relationship in a competitive environment, where when we see what can be the disruptions from an economic and human point of view of labor disputes from an individual or organizational point of view, having the capacity to be able to rely on skilled conciliators and mediators to be able to mitigate the impact of the disruptions of dispute in the workplace is fundamental if we want to get productive workplaces. So I think there's a critical element that we are very much interested to look at, and that is fundamental if we want to be able to get companies that are able to compete and that can get a productive workforce, is to get effective support for dispute prevention and mitigating the impact of disruption of conflict. And maybe a last point I'd like to emphasize, and I think this is something critical that is sometimes underlooked when we looked at conciliation and mediation in the context of labor disputes, is the creativity of the solutions that employers and workers can achieve through conciliation and mediation. That is usually far more interesting that what they can achieve through arbitrations or through adjudication, where the question of the creativity of the quality of the solution is sometimes not the most important aspect. But when it comes to conciliation and mediation, we know that conciliators, mediators are masters in supporting employers and workers to find and to and to find and to identify by themselves what can be some kind of creative and tailor-made solutions to their own dispute resolution problem. So I think that many advantages of conciliation and mediations, what they can bring, were mentioned by your panelists before. I think some of those make a special sense when it comes to the ongoing relationship between employers and workers, or between employers organization or employers and workers organization. The ILO has been supporting, and the ILO office in Kiev has been supporting ILO constituents when it comes to labor disputes for many years, and especially over the last years. I encourage everyone to look at the work that was done by the organizations when it comes to access to labor justice, and everyone to access the free online courses on conciliation and mediation of labor disputes, so that if you are not, you can get familiarized with the unique features of conciliation mediation in the labor sphere. Thanks very much, and congratulations for a very successful event.
Дуже дякую, пане Баффі, насправді за...
Thank you very much, Mr. Buffin, for presenting mediation in the context of labor disputes. This panel is over. I would like to thank all the speakers of this panel, Ukrainian stakeholders, representatives of European nations, representatives of Singapore. It is very valuable to us. We heard the prospects of mediation development in Ukraine. I think it was valuable, and Mr. Banchuk in particular admitted that more can be done, and of course the prospects are good. Thank you for admitting that there's room for improvement. We understand that there is no clear model about how mediation can be implemented in European countries, but I think for Ukraine, it is important to learn from experiences of other nations, from their success stories, as well as learning from their challenges. And that makes this forum so valuable. So again, thank you, and I'd like to pass on to Luiza for further comments.